Made your easy lordship. Madam, with the concern of the other side, I beg to mention item numbers 9 to 13 of the hearing this, my lord. Madam, the learned advocate general appears in this matter. Madam, he's out of station, my lord.
How long can we adjourn matters because learned advocate general is not available?
Madam, he'll be available after 13th of June.
After 13th, so what should we do till 13th?
Madam,
We should keep on it. This is totally uncalled for, I will tell you.
Madam.
You express great displeasure. The court being asked to adjourn the matters because the advocate general is not here for half of the month. Absolutely unacceptable, we will tell you. These are not summer vacations. State has to make its own arrangements. If we are not adjourning the matters, we'll hear them. All right. Yes, this is not done.
If my lord permits, my lord, if my lord hears this matter tomorrow, my lord.
Day after tomorrow.
Deeply obliged.
His own things to do. Yes.
To the concern of the other side, I'd like to mention item number 14 to 16. 14 to 16.
Why? Why? What is the reason?
Lordship,
These are appeals of 2020 and 2019.
Lordships, in this matter, senior counsel Mr. Didas appears.
So
He was supposed to be in Azal yesterday and today, but he reached Guwahati yesterday late in the evening. Lordship, he did not get the opportunity to produce the brief. Lordship,
how much time does it take? Let's see. We'll start the matters. We'll see how much time does it take. We also not read the files. We'll do it together. Ask him to be here.
in that case, Lordship, tomorrow.
Day after tomorrow.
Lordship, day after tomorrow, he'll be in Nagaland. Lordship.
So we should adjust our hearing board to suit the availability of senior counsel. Is that so? How are these requests being made? We don't understand. No brief can be adjourned because senior advocate is not available. The client has to make own arrangements then. We are now issuing a direction. Names of none of the senior advocates will be reflected in the cause list. Today only we are issuing that direction. The client has to make arrangements. Senior advocate, designated seniors' names are not reflected in the cause list. It's not the correct practice. Client has to make arrangements. This is not done, madam. Sorry. We have got a board only of 20 matters, and out of that, 13 are adjourned. What are we supposed to do? We are answerable to the Constitution. We get up at 11 o'clock. Tell Mr. Das, address through VC.
Only 11 matters from adjourned.
He's here in Guwahati.
Yes, sir.
He's in the court.
Yes, Your Lordship.
Call him. This is not, absolutely not done. We'll take the matters, we'll hear them.
Please, Your Lordship, I beg to mention item number 23, my Lordship. That is listed for your Lordship. I'm seeking 2 weeks accommodation, my Lordship.
Why?
Lordship, a similar Lordship here, senior is not available, my Lordship. We have informed the other side also, Lordship. The other side will not be prepared.
We request learned senior advocates present here to please advise the court
Lordship,
whether a matter can be adjourned, and that too in the hearing list, because the senior advocate is not here.
Lordship, I apologize for that. Lordship, we have.
This was a complaint coming from the bar
Lordship,
that the hearing matters are not being taken up.
Lordship, we won't repeat such thing.
This is being done regularly, Mr. Counsel. Every day.
Lordship,
Day after tomorrow. All right.
Lordship, day after.
Day after tomorrow, yes.
Lordship.
23rd, day after tomorrow.
Obliged, Lordship.
May I please, Your Lordship? Your Lordship, I'd beg to mention item number 21 and 22. I would apologize.
Come out with a better excuse.
No, Your Lordship, the senior counsel is actually unwell, Your Lordship. His brain condition is not really well. Your Lordship may kindly give a short date. And for the private respondents, Your Lordship.
Who is the senior advocate?
Mr. J. Roy.
Mr. J, it is stated that senior advocate, arguing counsel Mr. J. Roy is unwell and a request is made to adjourn the matter on his behalf. The appellant's counsel has no objection. List up to 2 weeks.
Much obliged, Your Lordship.
He's not for a long time. In the court.
Quite a long.
Ah.
May I please, Your Lordship? I beg to mention item number 20. We want to withdraw the matter.
Then council 20.
20.
Then counsel for the appellant craves liberty to withdraw in the instant date appeal. Hence, the same is disposed of as withdrawn. The caveat is discharged.
May I please, Your Lordship? Lordship, with the consent of the other side, I beg to mention item number 24, Lordship.
24.
Lordship,
Yes.
Lordship, I pray for adjournment for the day, Lordship.
Why?
Lordship, some personal difficulty, Lordship. Here, Lordship, for here we are, Lordship.
Short date may be given. I am the appellant.
He-
I am the appellant. My lord.
Yes.
Short date may be given.
He is representing the respondent number 6. He is the respondent number 6, the contesting respondent.
Lordship,
All right, 23 appeal we can adjourn. And counsel for the contesting respondent number 6, praise for time, as it is stated that arguing counsel, so A.R. Boyan is having some personal difficulty today. List up to 2 weeks.
keep your Lordship.
7 and 8.
You appear. That for another time, yes. कौन लोग जब रिक्वेस्ट कर देंगे? Yes.
My lord, may it please the lordships.
Yes, please.
My lord, this is an appeal filed by the state of Sikkim, which was transferred to your lordships. Yes, my lord. My lord, my predicament is not personal. Personal predicaments are there. I am not well, but I am not argue that. My lord, I find the pleadings are not ready. In the sense, on this 25th, my lord, a set of pleadings have been filed by the respondent lead petitioner, which need to be countered, my lord. Apart from that, my lord, there is a miscellaneous case, although may not be of very high bearing, a miscellaneous case of which counter has been filed by them, reply is yet to be given, rejoinder is yet to be given by us. Now, when I find, my lord, the rejoinder was almost ready to be filed. On that point, the pleadings filed before your lordship probably on 26th or 25. I was given a copy on 25th. My lord, that needs to be counted. And my lord, as lordship, this is a matter where I think all of us will agree, my lord, will have a very high ramification. And my lord, all the cases have.
Is that a veiled threat to the court?
No.
We are not bothered, don't worry.
Absolutely, we are also not bothered, my lord.
Yes.
Both of us are here only to assist your lordships, and
Yes.
luckily both of us are from Guwahati. So, my lord, we are not going to Sikkim anymore. No, but my lord, everything said and done, I owe a responsibility both to
All
my
right, how much
client.
time do you want to file the pleadings, please?
My lord, my juniors have remitted the matter to Gangtok. Your lordship knows, government brief, a pair-wise comment to be vetted by, my lord, some reasonable time. I will not
Counsel
say
for the
anything to your lordship.
Appellant.
Whatever grace flows from your
You
lordship.
have filed things on
No, my
25th,
lord,
Mr. Chaudhary.
pleadings which were brought on record is a judgment of the Honorable Supreme Court and the
So why were you
consequential
required to file
amendment to
it?
the Income Tax Act.
Why were you required to file it? You shouldn't have filed it. You could have just argued it when the matter was taken up. You have
We
given them
brought
that
out any
opportunity.
new facts.
That's it. There are some new facts which need to be countered, my lord, which need to be answered, I'll say.
You have given that chance to learn counsel for the appellant. All right, and counsel for the appellant submits that as fresh pleadings have been filed on behalf of the respondents shortly herein before come on. He needs short opportunity to file a counter thereto. If praise for it is granted, how much time, sir?
My lord, anything that falls from your lordship, I'll pray for a month. Because, my lord,
Month
what
will
happened?
take us to.
A month means
No.
2
Before that,
months.
before that. My lord, any date subject to your lordship's
It's a matter
convenience.
of recruitment.
My lord, I want a leverage to the extent that next time I am not even
List
allowed
on-
to make a request.
List on 22nd June.
22nd June. My lord, we'll do something. We'll do something.
Can we please do that?
In this case, my lord, I have received 2 affidavit oppositions, and I need to file the reply of both the affidavit, my lord.
Then counsel Mr. Purkar submits that he is received the affidavits in opposition filed on behalf of the respondents and needs some time to file a reply thereto. Time period for is allowed list up to 3 weeks.
My last, any date in the last week of June, my lord.
Whenever it comes up, sir, 3 weeks.
Item number 3.
Yes.
May it please your lordship. Lordship, the affidavit received by me on behalf of the state government has not come on board as yet.
That will come, don't worry. What have they
We
mentioned?
have e-filed the
They
matter,
have-
lordship. And we have already e-filed the matter, lordship, in
My-
today morning.
They have done the e-filing, good.
On behalf of the fishery department, my lord,
Mm,
there is one particular annexure, if I may be permitted to read.
mm.
My lord, this was issued by
Can we
the
get the affidavit, please?
It is filed today morning, lordship.
Today morning.
Yes, lordship.
Affidavit on
received it
behalf of the
yesterday.
respondents has been filed today morning. The same we brought on record.
May I
List-
please your lordship. Lordship, I filed an IA of inclusion of all Andhra Pradesh Farmers Association, lordship. There.
That is also not there in the with the
Yes,
file.
lordship.
I have not
That,
received
along with
that
one
as
four
well.
two eight, IA number 1428.
The same be brought on record. Interlocutory application filed by Land Council, Mr. So and so. What's the good name, sir?
BP Bora, lordship.
BP Vora shall also be tagged with the record.
My
The
lord,
matter shall be re-notified on 22nd. No, sorry, not 22nd. Will come upon 1st June.
my lord, copy may be directed to be served. I have
They
not
have filed it
received the IA.
e-filing. Have you sent a
Yes,
mail to
yes,
them also?
lordship.
Affidavit in opposition, I have
Then-
received the IA.
IA, give a copy.
Deeply obliged.
Item number 4.
Lordship, here in this matter, I have received instruction, Lordship. I may be allowed some time to file my reply, Lordship.
Instructions on behalf of whom?
On behalf of the Health Department, Lordship, that is the
You
addition.
were already there on 18th May.
Lordship,
Mr. D. Upmanya.
yes, Lordship,
So you are D. Upmanya.
yes, Lord.
You were
I-
there on 18th May when the
Yes.
matter was taken up.
Yes, Lord.
So
I have received the instruction on behalf of the government, Lordship. And-
now,
Yes, Lordship.
Mr.
yes, sir.
Upmanya submit that he has received instructions on behalf of this Family and Welfare Department and needs some time to file an affidavit on behalf of the state. What is the controversy? That hospital matter. The interim order shall continue. Now let's take it in second week of, third week of July then.
Lord, may I pray only one thing? I have read out the all facts, my lord. In all Assam, my lord, a position is to be clarified before this honorable court that in each district, how much bed facility they have provided. Only one line, my lord.
That will be, you file the
Let us.
details on record, then they'll have to reply. If that is not a part of your
My lord, they are
petition,
Coming affidavit, only one part if they clarify.
gentlemen, no oral submissions. File it on record through an affidavit.
Madam.
Then we'll call them
Madam.
upon to respond.
Deeply.
List on pleadings on behalf of all the parties be completed by next date, list on 21st July. Interim order shall continue till then.
Highly obliged.
Supplementary.
Supplementary list, item 25.
Lordship, in this matter, I pray for 2 days accommodation, lordship. Kindly take the matter on Friday, lordship.
As briefed by MS M. Bhattacharya. List, what is it about?
Matter, my lord, regarding, my lord,
PTNDS, lordship.
preventive detention of the.
And
Yes,
DPS.
lordship.
Where is the order of confirmation? There is an order of confirmation.
Subsequent, it is passed very recently.
Yes, lordship. I want to
subsequently
bring
it is
this
passed,
on
my lord.
record.
Subsequently means
My lord, my lord, I think, my lord, this is 19th May, na?
19th May.
Yes, ma'am.
What is the date of initial detention?
My lord,
On February.
it is, my lord, on my lord, page 40, my lord, dated, sorry, my lord, it is dated, my 11/11/2022, my lord.
3 months. Tomorrow.
No,
This
lordship.
is
I will
every
tell you
minute. You just place on record the confirmation.
Lordship, lordship.
And Council MSM Bhattacharya shall place on record the order of confirmation of detention passed, if any, in relation to the petitioner on record.
Lordship,
Every minute's detention is illegal. We have already held in that judgment.
lord.
Obliged.
General order here. Is there? Brother, It was just single bench dismissing. Just Sanjay Mehta entertained the dismissal. Respondent 10 months. Then we asked. They have done a lot of litigation, but then. Right. 10 months. Information on it. No one was even aware.
And if you quote
Judgment is for 25. Everything was about. They are not even aware. Tomorrow. Yes. Yes.
Delhi list, item number 5 for hearing.
Please, Your Lordship. And this is regarding appointment of district malaria officers, 14 posts. It was advertised in the month of December 2012. My lord, before I begin this, my lord, during the pendency of the writ appeal, the writ petitioner, the respondents have filed a writ petition for implementation of the order passed by the learned single judge. And there they got an order that they should be appointed. They should be appointed within a period of 4 months or at the earliest. And we filed the review petition that is pending. I'm informing your lordship.
So would it have any implication on this appeal?
That order is already there, that they are to implement the order.
So that order is under challenge in this appeal?
No. First order which was passed, my lord, during the pendency, we have challenged that order, and during the pendency of this writ appeal, my lord, they have filed another writ petition for implementation of the order passed by the learned single judge. And there they got an order for appointment of the respondent.
Yes.
And they got
In terms of the order, which is under challenge here.
Yes.
That's what we are saying.
That your lordship will find that my additional affidavit I have given in reply. That I'm pointing it out, my lord, it may not make much difference.
Yes.
Because that once your lordship takes a final call, my lord, your lordship will kindly see first advertisement was issued, page 51.
Yes.
This is by Assam Public Service Commission. Relevant is at page 53, my lord.
53.
3.
Yes.
When the number of applications, because my lord, written test marks were not taken into consideration. Only the interview marks were taken into consideration.
For final appointment.
Final appointment. That was the challenge in this.
What is the scheme of the rules?
Scheme of the rule, they have followed, my lord, APSC. They say, my lord, the APSC rules are there. And, my lord, let me.
When you present your case
Yes.
for your convenience.
My lord, your lordship will can see page 53.
Yes, please.
The top, my lord, the number of applications received are large. If the number of applications are received large, the commission may shortlist the number of candidates either on the basis of their marks obtained in a qualifying academic examination required or by holding written examination, which will be notified in due course. Only 53%.
So shortlisting procedure is either by qualifying the marks obtained in merit of marks obtained in qualifying or by a shortlisting examination.
56 persons participated in the process.
How many were the posts?
12 posts.
12 posts. Okay.
Now, my lord, the written examinations marks were declared. That your lordship will find 57 where the petitioner has been selected, my lord.
That is for shortlisting.
That, my lord, that do not say, my lord, here in the advertisement it says, my lord, but in the written examination she has passed.
She has passed. All
She
right.
has passed.
Yes.
But advertisement says if the number of applications are received are large, then the commission may shortlist it. Number of
So
applications
just hold on.
56.
This you are referring now to 56. That is the admission certificate.
Yes.
Or
No, the
notification.
57 is that results of the written examination.
57
Full mark.
Notification that it was
And
published
after
in
56,
newspaper.
Mr. Das.
Yes.
After 56, there is a notification of 2nd August 2010.
Yes,
Seems
that is the publication of the results of the written test. Yeah, originally is at page 58 in Assam Tribune.
No,
58, my lord. I have shown that the petitioner's name is here.
there is some error in your filing because you have annexed the rules, business rules 2010 just after 56. Maybe anyhow, that's an error. We'll omit that. Yes, 57.
Yes.
The following, this is the following candidates whose have roll numbers are shown below are declared to have qualified in the screening test. Screening is by what method as per the rules?
On the basis of the written test, they have done it, my lord.
We are asking you, sir. Written test you have qualified.
Yes.
Then
Then they.
this result is declared so as to put the candidates for screening.
Yes.
What is the mode of screening in the rules?
My lord, that rule, my lord, when they produced it, my lord, from the record, if your lordship sees, they have followed.
Rules of 2010 are the rules of, these are the rules. APSC
2010, yes.
procedure and conduct of business rules 2010.
Yes. My lord, now what has happened here,
Yes,
now
please.
after the results of the screening test, there is
Yes.
a telephone call to the petitioner saying that you must meet our demand. Without that, you will not be selected.
Hmm.
So thereafter, we filed a, my lord, FIR, but filing of the FIR was late by about 3 months. That is there. Then thereafter, my lord, your lordship will see that from the record, last time when the record was produced, how the marks on the interview were given. There are a lot of, my lord, overwriting in the marks. If you are satisfied there, my lord, I will have no case at all. Your lordship will see from the record how they have given the marks in the interview. And there is lot of overwriting and.
Before that, Mr. Das, satisfy us.
My lord.
Under the rules, if the ultimate result can be prepared on the basis of, or the qualifying, the candidates can be selected through an interview only. What do the rules say?
Rule says, my lord.
What is the mode of selection? Final mode of selection?
Yes. It's in the vivacy test, marks shall be allotted as below. 50% on academic professional
Sir,
qualification.
Which are the service rules applicable to the services in
This is
question?
APSC, my lord, Assam Public Service Commission, they follow their own rules.
Okay, now
So
read
these
in that rules.
It seems, my lord, they have followed these rules.
Does it provide
30,
rule 13?
30.
Okay. 30?
Yes.
Yes.
50% on academic professional qualifications, service experience relevant to the post preferential qualification, 50% for the subject knowledge and general bearing. Out of these 20 shall be for subject knowledge and the remaining 30% for general bearing. So this 30% general knowledge, general bearing, interview was taken by one Basant Dole, and my lord, another was, my lord, the person who telephoned us.
Service rules.
Rule 27.
My lord, one part.
Mr. Das, you are not able to get what we are trying to understand. Which are the service rules applicable to the?
My lord, this is the APSC service.
This is the procedure for conducting the examination,
This
sir.
is what they have done. Ma'am.
These are malaria inspectors. What is the post?
Malaria.
So,
District
there-
malaria officer.
sir, there must be service rules for the selection,
They-
mode of selection.
Yeah, that they have given it to the APSC. My lord. APSC has advertised. and
That is
APSC
an
follows the rules.
outsourcing for conducting the examination.
Yes.
But what is the mode of selection provided in the parent rules?
Parent rule, my lord, this district malaria officer, my lord, they do it through, my lord, APSC. Now they have their own separate rules.
Earlier, there were no rules governing the service.
Service
Are there any rules governing the service of district malaria officers, please? Subordinate medical service rules, medical service rules, whatever it be. Yes.
My lord, this, I'll not be able to give you this time. But they followed this.
Sir, you are not understanding. This is
I
just
understand.
the procedure.
I understand.
What is the mode of selection provided in the rules?
The lordship will take it at 2 PM. My lord, I will.
Ms. Chaudhary, will you be able to help us out?
My lord, lordship has posed a very relevant question.
Yes.
That aspect was not, they were highlighted by them.
Can you please point out?
Yes,
Yes.
I'll find out.
Because you see, APSC is
I found, my lord,
outsourcing,
there is one
outsourcing to hold the examination. But the mode of selection will be prescribed in the rules
Rules under the parent department.
under the parent department.
Apparently, my lord, they have followed this for the purpose of instant selection.
Yes.
This APSC rules, where, my lord, initially based on written examination, screening was done. Then based on the mark of the interview, my lord, the selection was made. Now there he doesn't see that she doesn't have any problem
Then
because Her problem is one telephone call came. This aspect has been dealt by the learned single judge.
All right, before we delve into that,
Yes, yes.
we would like to know what is
Regarding
the
that service rules.
service rules, please.
What I want to is what the law is trying to find out that under the service.
Whether selection by viva voce is permissible or not.
If they not provide, if the rule space is that no, it will be done by the HPC, then matter will be different.
And that's a different thing. But even the APSC would have to conduct the examination in accordance with the scheme provided in the rules.
Normally that is.
They
the
can't
rule.
go beyond that. If the rules do not permit selection by mere interview, then
Then the HPC cannot be done.
so there apparently is an anomaly.
If there is.
If the service rules do provide for a mode of
Possibly my
selection.
service will be silent for that. I have not know. I'll find out. I'll check. Your lordship.
Your lordship has posed a very relevant question. I'll have to see.
6 June. This issue strikes
At the very root.
and at the very beginning.
But my lord, the case was structured in a different altogether. The tangent was, my lord, that there was a telephone call. In spite of the telephone calls, you see, waits for 3
Ms.
months.
Chaudhary, that is the advantage of hearing the case without reading the judgment.
Correct.
So the query which is spontaneous comes to the mind.
Right.
Item number 6.
Yeah, my lord.
And in place of 6, can it be, seventh minor?
7th, all right, 7th.
7 June. Huh?
7th is not a hearing day. Anyhow, we'll take it up. Not an issue.
This is.
Is an appeal of 2019. Yes. It was next week. I'm taking the sheet with me. Yes, please.
I'm not feeling well. Still, I try my best, my lord, to argue the matter, my lord. Here, my lord, this writ petitioner, my lord,
Yes.
she approached this single bench, my lord, honorable single bench.
If you are finding it too difficult, we can give you an the accommodation. If you are finding it too difficult,
Lord,
let us know.
as the lord.
We'll not be so tough that council says that I'm not at all prepared and not feeling well, then we'll accommodate you. When do you want to do it?
As the lord.
When?
After 2 weeks, lord.
After 2 weeks.
As the lord.
We hope that you get well better very quickly. But you want to wait for 2 weeks. What is all right? Just give us a brief. What is the matter about?
Matter regarding selection, my lord. Selection of the principal, my lord. And at the time of selection, my lord, the constitution of the selection committee was vitiated by Rule 8(4), my lord, of the Rules 2003, my lord.
Okay.
And instead of the postgraduate teacher, one vice president of the managing committee was appointed, my lord. And it was totally vitiate the very purpose and object of the rules 8(4), my lord. And apart from that, it has also come to the notice of the petitioner, my lord, the process, my lord, regarding notifying if in the event of the principal in charge is appearing in the selection process, my lord, the inspector of schools has to notify, my lord. That is lacking in the present process, my lord. And that has been already, this honorable court has pointed out in the case, man.
All right. When do you want to do it? Tell us. 2 weeks.
Lord.
And counsel for Mr. Your good name, please. Submit that he is not feeling well and needs some time to prepare and argue the appeal. Great appeal. List after 2 weeks has played.
May I pray for a date, your lord?
Your client is already working as a
No,
principal.
your lord.
There's a stay.
Interim order is for me.
That's list on 6th June.
My lord, after a week,
6th June,
today is 30.
yes, 6th June. Calendar is there.
No, my paper was 2 weeks.
Sir, you
Since
are enjoying
No, no,
stay
not-
since
not-
2019. He has a right to object.
Yes, sir, right to object.
Yes.
But the thing is that since I'm not feeling well, that is.
Sir, we hope that you recover in 1 week.
As a lordship, as a
Yes, yes.
Obliged.
Item number 7 and 8.
Seven and 8, list before a bench of which Honorable Justice Lady Chaudhary is not a member.
Daily list, item 14 to 16.
This matter pertains to an allotment of land
Yes.
for opening a KVK. The appellant had made the application.
KVT.
KVK, Krishi Kendra
Krishi
Vidyalaya under the
Vikas Kendra.
ICAR.
Yes.
The only thing here is that we had taken consent of the other side to have this matter listed after 2 weeks.
Gentlemen, the consent in a hearing board can't be given by anyone
Well, the difficulty
except for the court.
the difficulty is that Mr. Das, senior advocate, is leading me in this matter.
Yes.
He was to be in Aizawl yesterday as well as today.
Mm.
He came back last evening because his matters got over. He did not get an opportunity to produce this file, madam. One accommodation, maybe 1 week or maybe 2.
What should we do after 11:30? Tell us.
I understand the difficulty, madam.
This is really totally unexpected. Councils rampantly asking for adjournment in hearing matters. Your relief sort was?
Madam, there was an allotment of land in my favor.
Yes. That
Now-
has been interfered.
Yes.
All right,
Much
then.
belatedly.
Then
Much
you are not prepared to argue the matter. We'll adjourn it, sign it. All right. Counsel for the appellant submits that he is not prepared to argue the appeals today. The cases are adjourned, sign it. Feel happy then.
Item 17.
This was 18. No, the one we adjourned. 14 to 16. And shall be listed only after the appellant's counsel moves an application showing justification for listing the cases in hearing category. Yes. This is item number 17. Yes,
Lordship, I pray for timing of the matter. My senior is on legs.
yes. Password for the time.
Item 18.
May it please your lordship. My lord, this writ appeal has been filed, my lord, against the, my lord, order dated 25/3/2021 passed in WPC 155 of 2020, my lord. My lord, the fact of the matter is that, my lord, the railway, NF Railway has floated a tender, my lord. And my lord, the respondent has become the L1 bidder, my lord.
Yes.
And the LOA was, my lord, issued to him, my lord. My lord, the contention of the respondent is that he has not received the letter of acceptance, but he has admitted the fact that the letter of acceptance issued through email, my lord, has been received by him, my lord. So, my lord, in a way, my lord, he has received the LOA, my lord. Thereafter, my lord, as per the contract agreement, he is supposed to sign the, as per the tender condition, my lord, he is supposed to sign the contract agreement within a period of 90 days, my lord. And my lord, by depositing the security deposit, my lord.
EMD.
Yes, my lord. My lord, he has been given, my lord, several letters, my lord, to come to sign the contract agreement by submitting the EMD, my lord. He has not been submitted. And as per the tender condition, my lord, if he doesn't submit the, my lord, signing the contract agreement, and my lord, by submitting the, my lord, earnest money, my lord, then my lord, he will forfeit the the earnest money deposited at the time of my lord filing of the tender, my lord. That is the crux of the matter, my lord. And now, my lord, I ordered it, my lord. I ordered it 25/3/2021, my lord. Yeah, my lord, and the my lord, termination letter was issued by the NFLA, my lord, and my lord, which was challenged by the respondent, my lord. And my lord, that writ petition challenging the termination order was allowed, my lord, and the railway was directed to return the earnest money, my lord. My lord, agreed by this by the order of the Honorable Learned Singh, that's my lord. We have preferred this, my lord. Lordship, may I take your lordship to the relevant provision, my lord, of the my lord contract agreement, my lord.
Yes.
At my lord, Annexure 8, page 29, my lord. May I read?
Yes.
Sorry, my lord.
Yes.
My lord, down below, my lord.
Performance guarantee.
My lord.
Yes.
Para my lord 36, the procedure for obtaining performance guarantee is outlined below. The successful bidder shall have to submit a performance guarantee (PG) within 30 days from the date of issue of letter of acceptance. Extension of time for submission of PG beyond 30 days and up to the date of submission of PG from the date of issue of LOA may be given by the authority who is competent to sign the contract agreement. However, a penal interest of 15% per annum shall be charged for the delay beyond 30 days. That is from the 31st day after the date of issue of LOA. In case the contractor fails to submit the requisite PG after 60 days from the date of issue of LOA, a notice shall be served to the contractor to deposit the PG immediately. However, not exceeding 90 days from the date of issue of LOA. In case the contractor fails to submit the requisite PG even after 90 days from the date of issue of LOA, the contract shall be terminated, duly forfeited EMD and other dues, if any, payable against the contract. The failed contractor shall be debarred from participating in the e-tender, the re-tender for that work. That is the my lord. There are other my lord, grounds, my lord, in my lord, similar manner, my lord. So, my lord, as per this, my lord, we have, my lord, issued, my lord, 3 letters, my lord.
That's three.
Because we are supposed to, my lord, issue those letters, my lord. My lord, those letters are, my lord, at Annexure 2, page 18, my lord. Sorry, my lord. Annexure 3, my lord. Annexure 3, page 20, my lord.
Page 20.
My lord.
Yes.
To AR Allied Subhadra JB. Subject, the contract, my lord. This office letter of acceptance referred above, you are required to submit a performance guarantee in the form of an irrevocable bank guarantee for an amount equal to 5% of the contract value within 30 days, 90 days with penal interest of 15% per annum as per clause 36A of the tender document from the date of issue of the letter of acceptance. In case you fail to submit the requisite PG within the prescribed time limit, the contract shall be terminated, duly forfeiting the EMD and other dues against the contract, and you will be debarred from participating in re-tender for this work. But even after 55 days passed from the day of issuance of LOA, you have not submitted the performance guarantee due to non-submission of the performance guarantee. Execution of contract agreement is held up on your account. You are therefore once again advised to submit the performance guarantee in the acceptable form immediately, failing which action will be initiated in terms of the contract condition. My lord, next letter, my lord. Similar letter was issued on 23/2019, my lord. Dear sir, in reference to above, it is directed to start the work in between Thakurganj to Pakhawali against Ariyar and Galgalia new line project as the required land to start the work in progress. Working session has already acquired and minor bridge drawing has also got approved. This is for your information. My lord, next letter. At page 22, my lord. Annexure 5. Yes, sir. In reference to the above letter, wherein it was requested to performance guarantee an amount equal to 5% of the contract value, that is for so-and-so amount within 30 days time, in the form of an irrevocable bank guarantee, performa and submit the program of work against the aforesaid acceptance letter, but no reply received from your end till then.
you are therefore once again request to submit performance guarantee an amount of rupees 3 crore 31 lakhs 50,000 for 48 and submit the program of work how to complete the work within the stipulated time at the earliest, please. So my lord, these are the letters sent, my lord. And my lord, while filing the writ petition, my lord, the respondent, my lord, has accepted the fact. My lord, lordship will find, my lord, at page 178, my lord.
Of receiving these letters?
Receiving these letters, my lord. Number one, my lord. Thereafter, my lord, he has annexed one letter, my lord, of at page 178, my lord.
178. What do you want to point out?
My lord, this letter was again written by the railway, my lord. In reference to the above letter, my lord, the subject is submission of performance guarantee, my lord, at the top subject.
This is the same letter you already read.
Yes, my lord.
Yes.
So, my lord, now, my lord,
This
he has
is the
received a
same
letter.
letter. 29th March, you already read that.
Yes, my
There's
lord.
an extra 5.
Yes, my lord. My lord, this letter he has received, my lord.
Yes.
My lord, next, my lord.
He has received.
Yes, my lord.
Yes.
He has admitted, my lord, this fact, my lord. My lord, this is, my lord, the writ petition, my lord, I have annexed, my lord.
Okay.
So, my lord, now, my lord, the next page, my lord, 179, my lord. He has written a letter, my lord, asking the railway authority to return the earnest money deposited at the time of filing of the tender, because his contention is that the land acquisition process has not been completed, so you should not give the he cannot perform the work, my lord. Nowhere in this letter, my lord, the letter dated 24/2019, which was written by the respondent, my lord, after receiving the letter, my lord, 29/3/2019, my lord, he has not accepted, my lord, mentioned the fact that he has not received the LOA, my lord. And my lord, in his writ petition, my lord, he has admitted the fact that the letter of acceptance, though it has not been received through, my lord, registered post, but, my lord, through email, he has received, my lord.
All right.
So now this is, my lord, one part of this, my lord. Yes, my lord. Now, my lord, the learned single judge, my lord, what the learned single judge has told, my lord, I would like to read the, my lord, a portion of the judgment, my lord.
Yes.
Page 199, my lord.
Paragraph.
Paragraph 13.
Yes.
Page 199, my lord. The tender paper those stipulate a condition for forfeiture of EMD for furnishing wrong information. The impugn forfeiture in the instant case is not on account of the said condition. The forfeiture of the instant case is consequence of termination of the contract hiding impugned order dated 2/5/2019. The issue which requires to be determined is as whether there was a concluded contract between the parties that would have been terminated. To come to a conclusion, one has to take recourse to the language of the tender and the documents connected thereto. There is a clear stipulation in the general condition of contract would be a part of the tender document, and as per the same, though other modes of communication could be available, all communication are required to be writing and delivered. In the instant case, though it appears that there was an acceptance letter dated 18/1/2019, there is no material to come to a conclusion that the said letter was delivered to the petitioner in writing. The endorsement of the postal department is not refused, but the endorsement is closed. Though an endorsement of refusal would have a different connotation, when the non-delivery because of closed, there is no scope of drawing a presumption of service and delivery of the letter dated 18/1/2019. That apart, this court also finds force in the argument made on behalf of the petitioner that is the stipulation in the acceptance letter dated 18/1/2019 regarding returning of the duly signed duplicate copy in all cases to come to a binding contract is also a relevant consideration, which was admittedly has not been done in the instant case. Though the learned standing counsel for railway may be correct in contending that the email of the acceptance letter has been accepted by the petitioners, the mode of communication is not enough to bring the court to a conclusion that the parties have arrived to conclude the contract. And my lord, Next, my lord, para 15, in view of the conclusion raised above, there was no concluded contract between the parties. The question of termination of contract would not arise. However, since termination is not subject matter of this writ petition, this court would refrain from making further comment of the said termination. However, the consequence of termination, which was forfeited of the EMD of an amount of rupees 51,51,870, is interfered with, and the same is hereby set aside.
You were just hold on. You were referring that against the termination also they filed a writ.
Yes.
Or this is the only writ.
My lord, this is the only lord. Both, my lord, termination and return
They
of.
prayed for both.
My
They question the termination also.
Yes, my lord. I will bring your lordship to the prayer portion of
Yes,
the
please,
writ
yes.
petition, my lord. Which is at page, my lord, 63, my lord.
Return are at my end. Then how can it challenge the termination? Yes.
My lord,
Page.
page 63, my lord.
One condition is that in view of your report, I cannot execute the.
I cannot
I
execute.
have not come to.
Yeah.
Then it comes in the condition.
Precisely that. Then how can he challenge the termination? 63.
My lord,
Yes.
Roman 2, my lord.
Mhm.
To set aside and quash the terminators notice dated 2/5/2019, my lord.
So where is the specific ground raised by them? They did not receive your communications.
My lord.
Let's see. And did you charge them the penal interest also?
No, my lord.
No.
No, only my lord. And my lord, my humble submission is that, my lord, we have, he has forfeited the earnest money on the basis of the tender contribution.
Yes.
Not on the basis of the
Contract.
contract.
Yes, yes, that we know, that we have seen. Yes. Where is the
My lord.
ground that they did not receive these letters?
My lord, he has mentioned, my lord.
Notice of termination,
My lord.
that is at para 24.
Um,
That to serve without serving any copy of the termination notice dated 20th May 19 to the petitioner.
my
So
lord.
they don't dispute the fact that the letters of March were not received by them.
My lord, page 50, my lord, para 12, my lord.
50.
50, page 12, my lord. Para 12, my lord, page 50, my lord.
Yes.
May I read, my lord?
Yes, yes, yes.
They
They admit rather.
that the petitioner exhausted that therefore the most an arbitrary and illegal manner the respondent issued alleged 2 letters bearing number so and so and so and so.
But then he is referring to his earlier letters of January,
Huh.
wherein he says that because of non-availability of site and delay in acquiring the land by the railways.
My lord.
What is your answer to this?
My
Para 11. What is your response?
My
in
lord,
reply?
para 11, my lord.
If you were not ready with the land,
My lord.
why should he accept it? Tell us.
My lord, we have given my lord in our even in opposition file in my lord writ petition.
Let's see. What's your response to para 11?
My lord, page 88 or 188, my lord.
Para 11, read please.
My lord, page 188, my lord, at para 7, my lord. That the statement made in para 7 of the writ petition, Deponent Baxter said that the position of the land acquisition from Araria to Galgalia busy line projects were furnished to chief engineer, height letter dated 3/1/2019 as under section Pawakhali to Thakurganj. Total land to be acquired, my lord, 365.7 acre. Up to date, payment made to landowner as on 150 acres, my lord. So it has been acquired, 150 acres has been acquired. Again, my lord, the third, my lord, land handed over to railway as on 2/1/2019 is 90 acre. Remaining acquisition of land is 215 acre is also under
So your
process.
case is that you could have started work on this 90 acres.
Yes, my lord. It is, my lord, gradually, my lord, it has been, my lord, payment has been made, my lord. And my lord, and my lord, in support of my conclusion, my lord, I would like to place, my lord, one judgment by the Honorable Supreme Court, my lord, reported in 2011-13 SCC, my lord, page
Yes.
200, my lord.
Yes. You know. Volume.
2003 to 2003, Malam, I'll first read Malam 2003 7 SCC 410 Malam. Read first Malam. Para 9 Malam. 2003 Malam. Two thousand three 7 SCC.
Page 200.
Malam 410 Malam. Page 2003 7 SCC Malam.
Yes, page.
Page 410 Malam. Para 9 Malam 9 Malam. Para 9 Malam. Para 9 Malam.
Yes.
Malam. In our view, the High Court fell in error in so holding by invoking bank guarantee and or enforcing the bid security. There is no statutory right exercise of which was being fettered. There is no term in the contract which is contrary to the provision of Indian Contract Act. The Indian Contract Act merely provides that a person can withdraw his offer. He's saying about withdrawal of the offer, my lord.
Yes.
Withdrawing the offer, his offer before its acceptance, but withdrawal on offer withdrawal on offer before its acceptance is completely different aspect from forfeiture of earnest oblique security money which has been given for a particular purpose. A person may have right to withdraw his offer, but if he has made his offer on a condition that some area earnest money will be forfeited for not entering into contract, or if some act is not performed, then even though he may have right to withdraw his offer, he has no right to claim that the earnest oblique security be returned to him.
It's a bit. The onus was on him. Pay the. Yes, please. Yes.
And my lord, in some others as well, my lord, while my lord Honorable Supreme Court discussing section 73 and 74 of the my lord Contract Act, my lord, it has been permitted that the earnest money can be forfeited by.
Which judgment you are relying?
My lord, 2021 9 SCC page 166.
Yes.
My lord, last para, my lord, para 27, my lord. The result of the aforesaid is that, as rightly held in terms of the impugn order, all that the appellants can do is to forfeit the bid security, my lord, amount, and thus it was directed. Since as a precondition of any coercive action, this is not my lord relevant, my lord. It was my lord directed to my lord for forfeit the my lord, the bid security.
Basically, you are not acting. That is your argument is you are not acting on account of non-performance of conditions of the contract. This is violation of the terms of the NIT.
Terms of the contract.
That is what NIT.
Yes, my lord.
On which you are acting. Yes. All right.
And my lord, another judgment, my lord, where my lord, it is hold that my lord, while my lord forfeiting the my lord earnest money, section 74 of the Contract Act, my lord, does not have any application. My lord.
Let's see that judgment.
My lord, it is 2015 4 SCC, page 136, my lord.
136.
My lord, page 136, my lord. The relevant portion I'll read, my lord. Relevant portion, my lord. My lord, relevant portion, my lord.
In this, the forfeiture was interfered.
Yes, my lord. Forfeiture, my lord, for remaining portion, my lord.
All
That is the, my lord, security deposit which was submitted after, my lord.
After the-
contract, my lord.
all right.
But, my lord, here, my lord, there are 43.7, my lord. Last phase probably
Yes.
43.6, we will say, my lord. Section 74 will
Yes, yes,
apply
yes.
to cases.
Very clear. Justice Nariman's judgment. Yes.
Section 74 will apply to cases of forfeiture of earnest money under a contract. Where, however, forfeiture takes place under the terms and condition of a public auction before agreement is reached, Section 74 would have no application. So, my lord, before my lord contract was signed, my lord, on the basis of the, my lord, tender condition, my lord, it was forfeited, my lord. And, my lord, the LOA, my lord, has been, my lord, delivered. Of course, my lord, through, my lord, email, and, my lord, he has not disputed the fact, my lord. That has been my humble suggestion before.
Yes.
My lord, your lordship may kindly come to the acceptance letter, my lord. At page number, my lord, 18.
Yes.
Now, the second page is, my lord, page number 19. Last paragraph, my lord.
Ji.
An additional copy of this acceptance letter is also enclosed herewith, which may be returned duly signed in all the pages for binding contract. These have not been received by me. Now,
Is there any denial?
yes.
Is there any denial?
Yes, my lord.
Let's
Your
see.
lordship may kindly come to page 47.
Yes.
Paragraph 8, my lord.
Yes. Denial in writing, not in the writ petition. Denial in writing during the pendency of this dispute. Any denial by you?
Yes.
Your letter, which you wrote in May, doesn't say that you did not receive these documents.
I
Read that
received
letter,
through
please.
email, my lord. Through email, not the hard copy.
Read your letter, wherein you say that because the land has not been acquired, I will not be able to do the work.
The first I am referring, my lord, the page 47, my lord.
Sir, read page 179.
Reference tender number so and so on our earlier letter 18-1.
Now, where are those earlier letters? You have got copies? See, if we did not receive the LOA, why you wrote those earlier letters?
Because through email we received the acceptance letter.
Gentlemen, did you ever communicate to them that we have not received the hard copy? Why you wrote those letters? This letter is in continuous to the earlier letters. When you raise a plea that land has not been acquired, so we are not able to do the work. There is no plea that you have not received the LOA.
Because through email we received, that is why we did not say.
Gentlemen, where is the objection to this effect that we have not received it? What is the problem in the email? Download and print it and give it to them. What is the problem?
No, my lord, certain annexures are also enclosed. Schedule of items are also required to be enclosed with this.
Gentlemen, that is not your objection, please. That is never a ground in your replies to the railways that we have not received the LOA. Please send us the original with the schedule. You say we can't do the work, that's all.
Because the land acquisition process was under this.
Then this plea that we didn't receive the LOA, how does it stand, sir?
Because the condition of the NIT is safe.
All right, sir. Okay, that's all.
No, I am coming to that. Paragraph 8, my lord, page 47.
Yes.
That the petitioners beg to state that surprisingly, when the respondent received the said letter dated 12/1/2019, hurriedly they issued a letter of acceptance on the same date, that is 18/1/2019 through email, ignoring the request of the petitioner. While letter of acceptance dated 18/1/2019. However, till today, the respondents have not served the hard copy of the said acceptance letter along with the additional copy of acceptance letter for signing by the petitioner as per the requirement of the letter of acceptance dated 18/1/2019, read with GCC 2013 for binding contract. Now their reply, I am coming to that, my lord. Paragraph 189, their
Yes.
reply. Page number 189, my lord. Paragraph 8. That the statements made in paragraph 8 of the writ petition are wholly denied by the answering respondent as false, fabricated, and incorrect. The deponent further begs to state that acceptance letter dated 18/1/2019 was issued and dispatched on 21/1/2019 to the
Yes.
present petitioner by speed post. Accordingly, the postal staff attended to the address on 30/1/2019, 31/1/2019, and 1/2/2019, and found the addressee door was always locked, and accordingly, they have returned the acceptance
So
letter.
you are avoiding it, sir. You are avoiding it. Then they sent it by mail. That is an acceptable form of
Now,
communication.
where is that letter, my lord?
Sir,
They
have
are
you
saying
denied
that-
this?
That they are saying
Have you
that
denied this by a rejoinder?
rejoinder is there, my lord.
Right, let us see. What have you said about para 8? Rejoinder, let's read at page number.
Here they have not enclosed this.
Yes, yes.
They have
Yes,
not,
please.
they have not annexed.
Rejoinder.
Yes, I have the copy, they have not annexed here.
They have not annexed your rejoinder. Affidavit in reply. Why have you not filed it, sir?
My lord, probably, my lord, that was not in my position. That is why, my lord, I have not filed, my lord.
What have you said? Let us see.
That the statements made in paragraph 8 by the respondents in their affidavit in opposition are not admitted by the deponent as the same are not true. The respondent, despite being state, made false and fabricated statement without disclosing the relevant and material fact, as they have not disclosed as to when they have received the letter dated 12/1/2019 from the district land officer Kishanganj about the status of the land acquired, and as per the letter of the district land officer, large part of the land of the site was yet to be acquired. The deponent begs to state that the respondents have made the statement that the acceptance letter dated 18/1/2019 was issued and dispatched on 21/1/2019 to the petitioner by speed post, and postal staff attended to the addressee on 30/1/2019, 31/1/2019, and 1/2/2019, and found the addressee door always open. This statement of the respondent is based on no document, and as such the same are denied. The respondents have not disclosed the alleged addressee address. It is denied that
All right, get that envelope.
My lord, probably, my lord, that is on record, my lord.
That envelope is on record.
Probably, my lord, I have, my lord, to submit to correction, my lord. I have seen, my lord, yeah, we have annexed, my lord, with our affidavit.
Yes, it's there.
My lord.
No, letter. Letter, when did you file it? Is there filing, any filing on record?
As per index, it is not.
As per the index, it is not there.
My lord.
As per the index, it is not there.
My lord, yes, my lord, probably. Probably it's not there, my lord. My lord, may I see, my lord, the record, my lord?
Yes, sure.
Because, my lord,
Get the original file of writ petition. We'll check
yes, my
it.
lord. Yes, my lord. Yes, my lord. Here it is not available, my lord. In the original file, my lord.
Original file of writ petition, get it.
Probably, my lord, is.
Yes, call it. Not an issue. Call the next year. Wait for a while, sir. We'll get the original file.
My lord, actually, my lord, my lord, in singles, before the singles, my lord, I was not there. My lord,
We'll check from the record.
My lord, submitted to me, my lord, provided to me, I have only an next, my lord. I don't annex the.
We'll check from the record. Don't worry. We'll get the original file right. Yes, 17 call coverage.
One of the matter relates to recruitment of a grade 4 staff, my lord, in the district legal services authority. Lordship will kindly come to the, my lord, page 39, my lord. The issue is regarding experience, my lord, of working in a subordinate judiciary. That is the issue. First, may I have your lordship's kind attention to page 43, the advertisement.
Yes.
Office of the Districts and Session Judge cum Chairman, District Legal Services Authority, Kamrup, Assam. Lordship will kindly come to 2B for the post of peon, class 8 standard pass. Preference will be given to those candidates who have already worked or working temporarily as contractual fixed pay wages basis in subordinate judicial court/office. Then, my lord, this was the advertisement, my lord, where now, my lord, at page number 46.
Yes.
Now, at serial number 15, my lord, that is Mrinal Kumar Nath, that is respondent number 4, who has been selected. And at page number 51, serial number 85, Ratul Deka, the appellant, my lord, they were called for interview. Eventually, my lord, at page 61, is the select list. The respondent number 4 was selected, my lord. And the petitioner number 1, the appellant was placed at waiting list number 1. Yes. My lord, the bone of contention is whether the mark on account of experience given to respondent number 4 was correct. That's the issue, my lord. Now, in the affidavit filed by the, my lord, District Legal Services Authority at page number 86, 7.
Where are the mark sheet, the evaluation sheet?
Yes,
Where is
that,
it?
my lord, in the learned single judge's order, it is reflected at page 100, my lord.
You have not filed it on record.
My lord, that's the record.
You've got the original record? All right, we'll see.
Page 100, my lord.
Para,
The learned single judge has extracted that. Para 9, my lord, page 100.
Yes.
On a perusal of selection record produced, it is seen that selection board consisted of 4 members. It is seen that while petitioner got the score of 33 by adding the marks awarded by all 4 members, the respondent had got the score of 37 marks by adding the marks awarded by all the 4 members. In this order, for the sake of convenience, respondent number 1 is referred to as a chairman and 3 members are referred to as second, third, 4th member. Board had awarded the following marks to the petitioner and respondent number 4. Now, this is regarding, my lord, the appellant, that is a petitioner before the learned single judge. Now, kindly see, my lord, the experience column, I was given 7 by 4 member. A total, I got 33.
And
Then
even
next page, my lord.
the selected candidate also got 7 for experience.
Yes. Now, my lord, but he has no experience in subordinate judiciary. That is my case. He got 37. Now, please come to the affidavit, my lord, where the professors that what would be the selection criteria. Page 87. My case is hinges on this file. Paragraph 6. That in reply to the statements made in paragraph 6 of the petition, it is stated that in order to fill up 1 vacant post of LDA and 1 vacant post of peon in the office of the District Legal Services Authority, Kamrup, Guwahati, a selection board was constituted with 5 members on 19/1/2016. In the meeting of the selection board held on 29/2/16, it was resolved to advertise the vacant post, 1 LDA, 1 peon, and to advertise in 2 widely circulated daily newspapers, 1 English and 1 Assamese, to the District Information and Public Relation Office by following the rule. This is important. It was further resolved to give special weightage to candidates with similar experience in subordinate judiciary. It was also resolved that for the post of peon, candidate would have to appear only in viva voce.
Yes.
Now, my lord, will kindly come to next page, page 88, para 7. Initially, my lord, there were how 2 marks would be given by each member.
Yes.
That in reply to the statement made in paragraph 7 of the writ petition, it is stated that the total number of applications received for the post of peon was 506. 306 number of applications are found in order. In the meeting dated 21/12/16 of the selection board, it was decided to conduct viva voce on 22/1 and 23/1. Secretary, District Legal Services Authority, Kamrup, was requested to prepare the list of candidates and publish the same through the official website. It was further decided that selection board would conduct the viva voce of first 200 candidates on 22/1 and for the remaining candidate on 23/1. Each member of the
Mr.
selection.
Chaudhary, the post is of peon.
Yeah.
What special experience a peon gains in the court and while working in another office?
No, my lord, question is they themselves professes that.
Understood, sir, but you see the scheme of things.
True.
It's a post of a peon.
True,
What is the special experience he would gain while working in the court and while working in a government office? What would be the difference?
No, my lord, the question is.
Peon does the duties of peon,
No,
grade
true,
4.
Correct.
So
My lord will kindly.
had
come-
there been some special acts attached to that experience, we
Yes.
could have understood.
No, true, my lord, but then when they professes that the action will be in this manner. It has to be in that manner.
You see,
Now,
Mr.
my lord will
Chaudhary,
kindly come. to page-
interfering in intra-court rate appeal, the principle is the same as interfering in an appeal against acquittal. If two views are possible, don't interfere.
No, my lord, question is that
Yes.
is it a case where two view is possible?
Yes,
My lord will kindly come to page.
you say
81.
that the word judicial courts, judicial also governs the word office.
My lord will kindly
That's-
come to 81, my lord.
What is a judicial office? Tell us.
No, my lord, it's an job of a peon.
No.
It doesn't require. any
Let's come to
special-
your argument is that the first part of the place where the experience should be gained also governs the word after oblique hyphen,
Yes.
right?
Ah.
So that would mean, just let us come to the advertisement.
My lord, the land
Just-
single judge has given a justification.
Just a minute, sir. The argument is subordinate judicial court oblique offices. So what is a subordinate judicial office? Is there anything like a subordinate judicial office?
No, my lord, if we
Then
apply
it would have been, if the intention would have been to find out the experience only from a person who was working in the court as a peon, it would have been registry.
Yes. No, my lord, we'll go apply the justem generis principle.
Yes.
If we apply, then my lord, it will be have to be the specie will follow
If
the
there,
genus.
if there is a meaning to that,
Yes.
if there is no meaning, then what?
No, my lord, when they clearly say that preference will be given to those who are working in, my lord, the judicial establishment. Now, he himself says that page 81 about his experience. Please
Yes.
have a look at page 81, my lord. He filed an application IA where he states so,
81.
para 8 mile, para
Yes.
6, that the applicant submits that he is only breadwinner of his family. His academic credentials are also better than that of the opposite party, making him well-deserving candidate to the advocate. Applicant has attained the trade certificate is in so and so. Last sentence. The applicant has previously served against a post of LDA from so and so at a junior college. It is denied that condition to be of that which has not been applied. No, my lord, he himself says he's never worked in a judicial establishment. My lord, but for that sentence in, the affidavit of the District Legal Services Authority and this amendment, my lord, I don't have any case. Merely because somebody is given more marks, my lord, I cannot challenge because this court doesn't have the expertise. That we're aware. But question is, my lord, their professors that their action will be judged by these yardstick. That is where my humble submission is, my lord. The learned single judge has given a wrong meaning to that slash. Now he himself say. Well, it is not even a case of preference. Question of preference will come when other things are equal. जो पोस्ट को शासन किया है आनंद पोस्ट
Yes, please. Yes.
In fact, my lord, I may just indicate one thing. The matter was heard before when the Honorable Indian Chief Justice Dhulia was there, my lord. His lordship also explored whether there is any vacancy or whether
The waiting list you want us to operate. You just read the judgment day before yesterday of Honorable Justice Chandrachud. Operation of a waiting list. We also took a similar view in last time.
Yes.
Waiting list can't be operated indefinitely. Yes, please.
So I'm appearing for the candidate who has been appointed in
Yes.
2017 only. If your lordship will see the particular advertisement, I have filed an affidavit in this case because I was not able to file an affidavit in the.
Affidavit in appeal.
Yes, your lordship.
Let's see. That's what just Mr. Chaudhary was reading.
No,
Your
it was on
affidavit.
the IA. I have filed an IA for vacation of the interim order, but I was
There's a stay. There's an
No,
interim
no,
order.
no.
at that point of time.
Before the Lanet single judge.
All right.
My affidavit is of 25-3. What is got that?
Affidavit in opposition.
Yes, your lordship. In the region.
Anshuman Sharma. Yes.
Yes, your lordship.
Yes.
If your lordship will come to page 21.
Page.
Page 21. At the cost of repetition, I'm just pointing to
No,
the
no.
advertisement again.
You tell us the paragraphs because paging is otherwise.
Yes.
Tell us the paragraph of your affidavit.
No, I am referring to the annexes of this affidavit. That is annexer number 9.
No.
That continuation number here.
The annexure, there are two annexures. First is name of the form of application.
Yes.
Then which annexure you are talking about?
Annexer number 9, where is the advertisement?
Advertisement.
Yeah.
All right. Let's see that. Advertisement was there in the paper itself.
It was there.
Yes.
But I'm just placing it from my affidavit. So that
Yes. The read,
I can
please.
maintain the seriality.
Annexure 9 is your experience certificate.
The advertisement is annexer 9. Next.
Advertisement
next,
is-
Next page.
All right. Page 21. Yes.
Yes, Lord.
Read.
If a lordship will see that particular post was for the post of peon. It says post of peon class 8 standard pass. Now the preference, in my humble understanding, preference will only come when after the evaluation takes place, both the candidates are on the equal footing. And then only the preference clause will be attracted. That is my understanding. I may be wrong, but this is correction. So this particular preference, this aspect will come into the picture only when after the exercise of evaluation takes place, both the candidates are found to be in the equal footing. Then yes, this clause will be attracted and maybe some preference will come to him.
Where
But
does the advertisement indicate marks for experience?
Yes.
Does
lordship,
it
for-
give any such
No,
indication?
for that, may your lordship come to annexer number 11, that is the second page after this.
Meeting of selection board
Yes, it is
Yes.
there where the modality for
worked out.
was worked out.
All right.
So the resolution, I may read the resolution. Possible got that? Office of DLSA
Yes.
had received.
Experience.
So I'll just come to the experience.
Basis of work earlier done was never indicated in the advertisement. Then how they even gave it? Why we should look at that? Yes.
Now, if
Yes.
your lordship will see the marks, how the marks were supposed to be given. The 1, 2, 3, presentation of the candidate 4, general knowledge 4, experience of the candidate. Now, my understanding here, it does not say experience in judicial office. It is of a general
No, but
applicability.
issue here is, gentlemen,
Yes, Your Honor.
this is 2016. Advertisement was
2016.
16. So this was not a permissible criterion under the advertisement. How could they even have awarded marks of experience? On what basis? Where does your advertisement say that in the evaluation process, experience will be given a weightage or a marks?
Lordship, I have placed before your lordship entire record method, how this process was conducted method. Lordship, there are day-to-day.
Sir, we are putting you a simple question. Did your scheme of selection provide experience as a mode of counting marks, awarding marks?
That was the procedure adopted since there is no service rule in this regard.
Understood.
So therefore,
So now you bring out a criterion of experience, which is alien to the advertisement.
Got it.
even if it was not provided in the service rule, you should have stuck to the advertisement. How can you go beyond that?
Lordship, that is the selection committee, they have selection committee resolved.
It was to be made clear then in the advertisement that there will be marks for experience. How did you give marks? Tell us.
Lordship, that, to my understanding, Lord, experience may get
Experience for how many years? 1 year, 1 month?
What is this?
two
What is
months,
the criterion?
3 years.
What was the criterion of counting
Lordship
experience?
signed a record, my lord, that criteria was taken, adopted.
Yeah, the minutes are there with us.
Yes,
This criterion was decided in the meeting. What is?
21/12.
Yes. Now tell us, how will they grant marks for experience? What is the mode?
Lordship, that is there is a part of selection committee resolved to give mark. The experience gathered not only from the judicial appeal, from other. Since it is beyond-
That's the question, sir.
Lordship,
A man has worked for 10 days.
Lordship,
How many marks will you grant?
that is
It's totally arbitrary. If at all you don't have any rules, then you should have made it clear in the advertisement that this will be the criterion for grant of experience marks. You have gone beyond the advertisement. You don't have rules. So this is changing the rules of the game after the ball has started.
is
Any judgment you can cite wherein recruitment for the DLSA, the experience criterion has been affirmed.
Lordship, in 1996, 282. The Secretary Health Department, Hospital Dr. Anita, paragraph 9 million.
What is law laid down? Read. What is the proposition, please? Read. What is the ratio of the judgment?
And because development is
Lordship, may I read?
Yes. There.
The question of consideration whether such subdivision of marks by a commission on different phases awarding only 2.5 marks for higher qualification can be said to be arbitrary. Admittedly, there is no statutory rule or any guidelines issued by the government for the commission for purpose of evaluation on merit of the respective candidate. When public service commission, this is public service commission, the public service commission is required to select some candidate out of the number of applicants for certain posts. The sole authority or discretion is vested with the commission. The commission is required to evaluate the relative fitness and merit of the candidate, then select candidate in accordance with such evaluation. If for the that purpose, commission prescribes marks for different phases and then evaluates the merit, the process of evaluation cannot be considered to be arbitrary unless mark allotted for a particular phase is not on face of the.
These are marks for viva voce, for which criterion may be fixed by the evaluating committee. Here you are giving marks for a criterion which was not indicated in that.
Lordship, this post only viva voce was conducted.
In viva voce, you have given marks for experience,
Lordship,
which was not a permissible criterion.
Lordship.
What is the yardstick of granting experience marks?
That is
because the nothing.
myself as per affidavit, my lord.
Yes.
Lordship,
What is your notice? Let us see. Why the candidate will carry the experience certificates with him? Why? Tell us.
because perhaps
It was decided in advance.
no, my lord.
You bring the certificate, will give you the marks for that.
Because the lordship will find the mark not only awarded to the respondent of court, all candidates have been awarded in experience.
Maybe now we are on the fundamental of your entire process. That whether you had given any indication, tell us from your advertisement and from
Because
your gentlemen, from your invitation for the viva voce, notice for viva voce, was any candidate required to carry the experience certificate?
Lordship, since this award of marks is was a resolution of award of marks adopted in 21st of 21/12/2016. That marks is available, information available with me, my lord, and nothing is, my lord. So I'm placing the original record before Lordship. And so far as my understanding is that.
You read your notice, please. And page 44.
Lordship,
So this is not a ground by them also. Page 44. Yes, read notice for Viva was it?
Lordship.
Page annex
54.
6, page 44.
Yes. It is for information, it is for information to the applicants who have applied for the post of peer in the establishment of District Legal Service Authority, Kamrup, Guwahati, in response to the advertisement that is substantial, published in substantial that Viva for the post of peon will be held so and so and so and so. In the conference call of the district and session judge from 9 AM onward, the list of accepted candidates along with their the date for Viva can be viewed in official website of the Kamrup Metro District, that is in the office website so and so.
Tell us, Mr. Counsel, why were the candidates required to carry their experience certificates?
Lordship, I have record of 3 candidates, my lord. Perhaps they have enclosed the experience in.
We are asking you, when proceeding for Viva was a, why were the candidates required to carry their certificates?
That must have information I have to.
Call letters were also issued to the.
Call letter, let us see call letter.
That is what. I don't have a copy of the call.
Original certificate, original record is there.
Lordship,
Read.
Lordship,
Where is it? Pass on the original record and counsel. This is what is the basis of grant. Marks. Yes. Structured criteria known as the Fourier's. The arbitrariness, which we किसी को भी दे सकते हैं.
Writing principle. Lordship, the copy of the qualifier is not here because as per notice, notice that notice that annex 6, my lord.
Yes, that's what we are asking you.
That is.
Why were they required to carry their experience certificates? There was no indication in your advertisement. There is nothing in your notice for Viva. So why the experience certificates were required to be carried?
Advertisement for 5. Page 45. 2 copies of passport size photographs signed by the for application. Attestation copies of necessary education concern and other certificate, etc.
Lordship, the mark of experience is awarded as per resolution dated, my lord.
Sir, you have said that for third time.
Lordship.
Repetition. We are asking you that criterion was fixed subsequent to the advertisement.
Lordship.
Then what is the guideline by which the marks are to be awarded?
I have no information more than this record, my lord. And in my affidavit, I have stated in paragraph affidavit at lordship and affidavit.
Yes.
84.
Yes.
Paragraph 7, 9, and 10, my lord. That affidavit was filed on the basis of this record. And so far, my
only by bus.
My lord, one more thing, my lord. Even if award of experience mark is not as per advertisement or procedure, but even if that mark is not taken into
If that is
consideration.
not taken, what happens? Let us.
And still.
He stands higher. All right, we will ignore.
They have got those 7 marks in experience.
We'll ignore those marks.
My humble submission is,
Yes.
from him, this 7 mark has to be deduction. Because as far as the respondent number 4 is concerned, my lord,
Yes.
his 7 mark of experience has to be deducted because he doesn't have, because he speaks of spatial weightage. my lord.
Where is
Please
the-
come to page 87, my lord.
where are the marking? Where is
The marking is at page 100.
100. Let us
Yes.
see that.
Yes. I got 33, he got 37.
Yes. So both
no,
both the candidates remove the experience marks.
Then, my lord,
Then what happens?
then, my lord, page 87. Please come
Yes.
to page 87. Para 6, last sentence.
Yes.
It is the resolution of the board, my lords.
Hmm.
It was further resolved to give special weightage to the candidates with similar experience in
The
subordinate.
weightage will come when the two candidates stand at par.
No, my lord.
Then the question of weightage comes.
No, my lord. No, lordship is correct. When it comes to preference, yes, what the lordship is saying is correct.
Yes.
But here, my lord, they say,
So this
those who
affidavit,
have worked in-
sir, Mr. Chaudhary, we are basically governed by the advertisement. There is nothing like weightage.
yes,
Preference.
yes,
Preference comes when the candidates are placed at the par.
correct.
So we ignore the marks of interview. Then what happens?
No, my lord, there was a mandate to the members of the interview board that those who have, experience of working in subordinate judiciary, they should be given special weightage. Yes, that is, my lord, it amounts to changing the rule of the game after the advert that is there.
Yes, what we
But
are
my lord,
saying is,
the selection proceeded based on the instruction, resolution they have taken on 21/12. So, my lord, my humble submission is this thing has to be redone, my lord. Who gets, we don't know. But there is an infirmity in the decision-making process. This whole thing has to go, my lord. It has to be redone, that interview. They themselves say, my lord, that will give special weightage to those who are working in the subordinate judiciary. But for this affidavit, my lord, I wouldn't have had a case.
Sorry to hear that.
This one only. And at the moment, what will be template applied?
The age relaxation. We can get the age relaxation.
May I just submit?
Yes.
After the 21/12 meeting, the resolution was to give 2 marks for experience to the candidate. Does not say experience of what nature. These are general.
That's why the arbitrariness
Yes, Lord.
creeps
So
in,
therefore,
sir.
even if we now take out the
No,
experience,
no, that we can't do, that we can't do.
then
Then
both the candidates. will have
what about the
7
third
marks.
candidate? If we eliminate the marks of experience, where does the third candidate stand? We don't know. It's not a race between you two.
Yes,
There is a third man.
it's a 226, it's a public law remedy.
Honorable court. The third man is not the court is honorable.
Doesn't
But if
matter.
possible, see one thing.
We are changing we can't in a writ jurisdiction change the criterion which you adopted for making the selection.
Advertisement otherwise did not reveal any modality of
Yes.
marking the guideline.
So then we are again asking you,
Yes.
what is the basis of marking, giving marks for experience?
Yes. So as I could see. from
So the
resolution-
process is arbitrary on the face of the record.
As because it was-
Not even if we don't accept his argument that the experience should be in the judicial court or subordinate offices, even if that is not so, what is the mode? What is the process of evaluation? There's a clear element of arbitrariness there.
For that aspect, the other marks, presentation of the candidate, 4
Yes,
marks.
yes.
General knowledge, 4 marks.
They should have restricted to that only.
Even that also doesn't have
They
any
should-
modality as to what sort of.
That is all right. That is all right. That is that is ultimately the evaluation done by judicial
So
officers.
if in that Viva
But experience part, unless there is a structured guideline, there is a bound to be an arbitrariness.
I have an experience of 11 years of serving as a peon. The documents which were furnished. In fact, the candidate of Mr.
Gentlemen,
also
even,
gave us
even,
some-
even the medical services wherein the nurses, GNMs, where the experience certificates are around, there are guidelines. This has to be the experience
Lordship.
in this kind of scheme, in this kind of office. This is totally leaving it to the hands of the
Lordship,
interview
allow
board.
me 1 day time, then.
Yes.
I-
Day after tomorrow.
Lordship, if there is any guideline in this regard.
Yes, come out. Day after tomorrow.
The only thing is.
If the guideline had been there,
Because otherwise,
Mr. Council, if the guideline was there, you would not have been required to take that meeting of 21st December.
21-20, yes.
There was no need to take that.
otherwise, so far as preference clause is to my understanding, there is a clear judgment. my lord.
Otherwise, I'm.
Deeply obliged.
6 years now.
Day after tomorrow.
And I don't know how the modalities were worked out.
Yes.
Item number 18.
Yes, the record is here.
Malad, the affidavit in reply is there, Malad, but Malad, we have not annexed anything probably, Malad. Malad, I have taken instruction, Malad.
Get that envelope.
Malad,
Get that envelope. We'll see it here.
Yes.
There's no problem at all. Day after tomorrow. Then counsel for the appellant shall keep the original record available
Malad.
on the next date list on 1st June.
Deeply obliged.
Yes.
May I please, sir. So, my lord, here in this PL, my lord, the notification dates to 11/2021 is under silence, my lord. Because, my lord,
Challenged what?
because by this notification.
What have
my-
you challenged?
My lord. My lord, the notification dated 2/11/2021 is 40, my lord, is under silence, my lord. Because, my lord, by this notification, the Assam State Election Commission has been entrusted to, my lord, hold the election of the council, my lord, where there is a special rule for the council to conduct the election, my lord. So, my lord, DPL has been filed before the holding of the election, my lord, during the pendency of this PL, my lord. The election has been held, my lord, and newly, my lord, set of person has become, my lord. My lord, may I pray for, my lord, I may be allowed to amend the repetition by bringing all those elected person as a respondent. And my lord.
There is a procedure provided in law to challenge the election of a duly elected candidate.
There will be
Can it
election.
be done a writ petition?
My lord, because my lord, there is a order passed by this honorable
It's
court,
a
my lord.
pre-election dispute and post-election dispute.
My lord, I'm not saying that, but because they are the party, because my lord, without them, my lord, lordship may not pass any order also, because.
The issue
they are-
is, on principles, we may consider your prayer for future events. But whether we can set aside the election of a duly elected candidate in a writ
My
jurisdiction.
lord, without the, my lord, it should go through an election process, my lord, by
That's
election.
election
That I
petition.
know, my lord. That only because my lord, last order, my lord, here is one reflection is there, my lord, on 23rd/5/2022, my lord, there is an
Yes.
order,
Yes.
my lord, no, my lord, the court's order, my lord. Order dated 23/5/2022, my lord. The last line, my lord, however, it is also made clear that if the petitioner are successful in the petition, necessary legal consequence will follow, my lord. Because of that, my lord, if my lord, no need, my lord, then I go for my lord hearing, my lord.
So let's start the hearing. It's today for hearing only. It's listed today for hearing.
Otherwise, my lord, required, my lord. Anyway, my lord, matter is this, my lord. Lordship, my lord, this is the council, my lord, that is 6th schedule, my lord, where there is different set of rules, and the, my lord, there are constitutional provisions, 6th schedule, my lord.
Yes.
Or like a mini constitution, my lord.
Mm.
So in my lord, paragraph 27, my lord, 27, my lord, lordship may come to constitution, my lord.
Yes.
Sixth schedule, my lord, para 2, subclause 7, my lord.
Just.
My lord, sorry, para 6, my lord, first is 6, my lord. So for the past constitution, there should be a my rule by my lord.
Let's get to the rule. Yes.
6, my lord.
6th schedule area
My
rule.
lord, 6th schedule, paragraph 2, my lord.
Para 2.
Para 2, 6, my lord. The governor shall make rules for the first constitution of district council and the regional council in consultation with the existing tribal council or the other representative tribal organization.
No,
with
you
the-
are reading Part
6, my lord.
6 schedule, part
Para
6.
2, 6 schedule, para 2, subpara 6.
Para 2. Yes.
Married, my lord, again.
Yes.
The governor shall make rules for the first constitution of district council and the regional council in consultation with the existing tribal councils or other representative tribal organization with the autonomous district or region concerned, and such rule shall provide for composition of the district council, regional council, and the allocation of seats therein. The delimitation of territorial constituencies for the purpose of election to those councils, the qualifications for voting at such election and the preparation of electoral rules thereof, the qualifications for being elected at such election as member of the such council, the term of the office of the members, regional council, any other matter relating to connected with the election to nomination to the such council, the procedure and the conduct of business, including the power to act, not extending any vacancy in the district or regional council, the appointment of officer staff of the district council, regional council. These are the, my lord, according to the, my lord, this.
So the district council or regional council, as per clause 7, you say is empowered to even frame rules for elections. That is what your case is. Read from clause 6. What powers you are given are clearly indicated in clause 6. Does it give a right to form or to frame a rule?
The rule have been framed, my lord. They are bringing, my lord. The rule have been framed, my lord, accordingly. Accordingly, under the powers, my lord, this, my lord, the rule have been framed, my lord. Notified by the governor.
You want us to declare those rules ultra virus?
No, that is done in under the.
You stand that risk. On plain reading, the power is not there.
My lord.
You stand that risk. Take that risk if you want.
Only, my lord, that is decided, my lord. Under PL, my lord, the court has directed to frame the new rule. This is for the past constitution, my lord.
Yes.
Until unless the new rule is coming, that is, my lord, in my lord, enforced, my lord.
Let's hear.
So, my lord, according to this rule, election ought to have been conducted. That is my case, my lord.
Yes.
As this rule is there, my lord. So, my lord, by the notification, let's say, may go to the notification annexure 1 of the repetition, my lord, annexure 240, my lord. Page 40, my lord. Subpara 7 says that after first constitution, the council will, my lord, frame a new rules, my lord. That is under process, my lord. That is separate issue, my lord.
The rules are to frame in relation to matters specified in subpara 6.
My lord.
Let us see the matters specified in subpara 6.
My lord.
Read para A. Composition. Composition doesn't cover election.
My lord.
Delimitation.
My lord.
That is also not election. Qualifications for voting and preparation of electoral rolls. Qualification for being elected. Term of office. Other matter relating to connected with elections or nominations. F would be there. The very main subject of election. So this gives powers. Ancillary, other would be ancillary.
Again, this is the rule of election.
Preparation of election electorals. Primarily the task of election. Yes. The proviso in a 7 civil indication. Provided the control rules are made by the district or regional council under this subparagraph. The rules made by the governor under subparagraph 6 of this paragraph shall have the effect in respect of elections too. So basically
to the office,
to the office
procedure and.
Yes.
No.
Elections to the officers.
43.
43. Exclusion है ना 243
Not. Therefore, one of the plan for development is effective correct construction of it. That's it. State government will state electoral commission will not provide a volunteer. Their case is to be unfair, they can have their own election.
They can have their own. On the state election. Yes, ma'am. Some schedule area कहाँ?
Some 243
243
JC also says it's like exclusion.
नहीं, ये देखिए 6 schedule area which clause 1 of 243 23 clause 1 clause 1 किस चीज का ये देखिए 244 का clause nothing else.
Schedule and tribal.
Schedule and tribal. हाँ 244 tribal areas. ये 243 में exclusion है.
ZC also.
एक second. Nothing in what should apply to scheduled area. Referred to in clause 1. Clause 1 we are not concerned because this is fifth schedule. Meghalaya, Tripura, Mizoram. The provisions of fifth schedule shall apply to the administration and control of schedule in any state other than the Assam state of Assam. So fifth schedule का exclusion है part 1. Provisions of sixth schedule shall apply to administration of the tribal areas. These all tribal areas. That is mentioned in the sixth schedule.
Exclusion.
Schedule area. Title is schedule area. Schedule area. That's the to make tribal area. Again, tribal area is schedule area. Is schedule area tribal area? So मुझे I don't study much of this. There is an apparent discrepancy.
Yeah, please say, but I couldn't listen subjective. Provision of each schedule shall not apply to.
Shall apply.
Shall apply. The administration of schedule areas and schedule tribes in any state. Under attendance,
we are not bothered.
Now, the provision of schedule shall apply to the administration of tribal areas.
All right.
In the state of okay. So this schedule by virtue of 244 will
mean a tribal area. These are basically scheduled areas declared under 244.
These schedules are being amended whenever a new concept is created. So they go to them, during go to them.
These are the tribal. These are all people in these areas are tribal. Everyone. Tribals planet TSP. It's a new way of doing it. You can't use Area, you have given all the powers, including elections. Yes. Yes,
My lord, Lordship may come to 244, my lord.
yes.
Article 244 of the Constitution of India. My lord. May I read, my lord? The
Yes.
part, may I read, my lord? 1. The provision of the 5th schedule shall apply to the administration and control of the scheduled area and scheduled tribe in any state except other than Assam, Meghalaya, Tripura, and Mizoram. So, my lord, the 5th schedule is applicable to the rest of the except these porters applicable to the rest of the country. My lord. So, 2. The provision of 6th schedule shall apply to the administration of tribal areas in the state of Assam, Meghalaya, Tripura, and Mizoram.
Yes.
So here I'm specially matter of tribal areas, my lord. In the case of 5th schedule, my lord, this is tribal scheduled area and scheduled tribe. There are some differences there, my lord. So, my lord, this is the, my lord, the 6th schedule is, my lord, coming from the source of this part of this, my lord, 244, my lord. 2. Lordship may come to then, my lord. This is in part 9 of the Constitution, my lord. This 10, my lord. So, my lord, Lordship may come to the part 9, my lord. The whatever anything, my lord, part 9 is not applicable to the 6th schedule. That is my case, my lord. Lordship may come to the, my lord, 243 K, my lord. 243 K, my lord. The 243, my lord, it is relating to Panchayat, my lord, this chapter and the municipal, my lord. So, my lord, how the existence of Assam Panchayat is coming, my lord.
There's a difference in part C and schedule starts here. Yes. Two 40.
My lord, this is part 9 is, my lord, regarding Panchayat. 243 K, my lord. How the state election commission is coming, my lord? What is the existence of the state election? It is existence on the basis of, my lord, 243 K, my lord.
Yes.
Lordship married, my lord. Election to the Panchayat. The superintendent's direction and control of the preparation of electoral roll for and conduct of all election to the Panchayat.
Western State Election Commission.
State Election Commission consists of State Election Commission.
Yes.
So, my lord, this State Election Commission, my lord, under this provision of the, my lord. Secondly, my lord, Lordship come to, my lord, for 243 M, my lord. Lordship got it. Married, my lord. Nothing in the part shall apply to the scheduled areas referred in clause 1. In the tribal areas referred in clause 2. That means, my lord, in 244, 1 to, my lord, this part 9 is not applicable, my lord. So the Assam State Election Commission exists on the basis of 243 K, my lord. If it is coming under 243, my lord, how the State Election Commission, my lord, hold and conduct an election of a council where they have their own set of rules, my lord.
In light of this, the elected, yes, you're right.
Secondly, my lord, the Assam Panchayat Act also bars, my lord.
Assam
Panchayat Act, my lord.
is also prohibited.
The Assam State Election
Operation is
Commission are
not-
coming 114, section 114 of the Assam Panchayat.
Will not
Act, my
apply
lord.
in the autonomous
My lord.
areas. Constitution itself is excluded. Yes.
And here also, my lord, in the section 1, 2, my lord, subsection 2, it is barred, specifically barred, my lord.
But has the council made its own rules for elections?
That is my rule I have provided, my lord. That is a rule from in 1951 that is going on till, my lord, 2011, my lord. From 2011, my lord, some transformation is there, my lord.
All right, you in this background, you will have to complete them. Complete the elected persons.
My lord, my lord.
And council. Your good name, please.
M. Sarania, my lord.
M. Sarania submits that as in the intervening period during pendency of this writ petition, the elections have already been held in the Autonomous Council, Karbi Anglong, the petitioners are required to implead the elected persons as parties in this writ petition in light of observations made in order dated
23/5/2022.
23/2022.
With my
The-
lord, some relevant paragraph also required to be my lord amended, but because
Yes,
of this matter.
he also submits that he will also be required to make few amendments in the writ petition.
My lord.
Because the impleadment application as well as the amended writ petition, to file an entire writ petition
My lord.
amended,
Definitely.
be presented within 2 weeks,
My lord.
list thereafter.
My lord, then I have to file first that amendment petition, my lord.
Yes,
Thereafter,
yes,
the composite amended
yes,
petition.
composite petition. Madam. Yes,
My lord.
the application for amendment, impleadment, along with the amended writ petition, be filed within 2 weeks.
Highly obliged.
Just over.